Okay, hello again, and now we're going to focus on the stages of the courts or trial phases, if you will. So the first one is pretrial. Okay, again, pretrial is everything that happens before trial. And so some of the decisions that are made are, how do we dispose of this case? Does a person get a trial or a plea bargain? And do they sit in jail awaiting their trial, or are they released either on bail or on their own recognizance or into the custody of another person, which is something we do, for example, with juveniles, releasing them to their parents. Bail is not punishment. Bail is money paid to the court in exchange for release until the termination of your case. It's based on the assumption that we shouldn't be holding innocent people in jail. So since the state or the government has a right to have its day in court too, to have a trial, what bail is a promise that you'll come back. So it's a financial investment. You give the court money, and if you come back, you get your money back, minus some administrative fees. So it allows you to go back to your family, back to your job, instead of being held in jail, since you're innocent until proven guilty. Now, your bail can be denied by a judge, and you'll be held in what's known as preventive detention, if you're considered a flight risk that you think you're going to leave, and if you're considered a danger to the community, based on what you're alleged to have done and what you've done in the past, based on your record. There's some problems with bail that are discussed in the PowerPoint slideshow. And the ones I want to focus on are really, well, the one I really want to focus on, honestly, is the biases we do see in some places. Because you could argue it's unnecessary. You certainly argue that it's bias against the poor in all cases, because we see courts across the country, at least in some places, using bail and inflating bail just to hold people who the courts know can't afford it. So this is sort of a bias in favor of the rich and against the poor. So if you Google this, you'll see states making serious efforts to eliminate the bail system or to modify it significantly to eliminate this bias. Maybe, charging people bail based on what they can afford, for example. But the one thing I want to focus on the most is the biases we do see in some places. Now, remember, if something's biased everywhere at all times, it's called systemic or systematic bias or discrimination. But when we only see it in some places, we call it contextual discrimination. Biases, disparities, discrimination that is found in some contexts but not others. In Chapter 6, you'll see examples from studies of bias in bail and charging and things like that, and even plea bargaining that we do see in some jurisdictions where people of color, minorities, African Americans, Latinos, for example, are charged, are less likely to be granted bail, are charged inflated bail, face higher criminal charges, or are less likely to be offered plea bargains, or when they're offered plea bargains, they're offered tougher plea bargains. This is the kind of thing that we see in some jurisdictions. So that's consistent with the idea of innocent bias, or in this case, contextual bias found in some places at some times. In terms of plea bargaining, I mentioned 95% of people plead guilty. You might find that really interesting because Article 3 of the Constitution, which is linked in the PowerPoint slideshow, and the Sixth Amendment to the Constitution both say you shall have the right to trial. It's the key word. Shall means you will. It doesn't say you will have a trial. It says you will have the right to trial. Well, plea bargaining means that the prosecutor and the defense attorney enter into an agreement out of court where they determine what's going to happen to you without a trial. So there's no evidence presented. There's no witnesses. You don't cross-examine the witnesses. You don't present a defense. You waive all your rights, including your right to appeal the conviction and the sentence. And this is supposed to be voluntary, without coercion. So you can't be beaten into it or forced into it. And it has to be knowledgeable. You have to know what you're doing. So a judge will ask a defendant if you understand what you're doing. That's the way it's supposed to work. But you have to ask yourself, if someone's innocent, why would they plead guilty? And we know this happens for sure, without any question. Probably most people, even the vast majority of people who plead guilty, are guilty. But some, even a large number, are not. So why would they? Why would you plead guilty if you're innocent? Go back to, excuse me, go back to what we already talked about. The courts are biased in favor there's an imbalance of power in favor of the prosecutor. If your defense attorney says, hell yeah, man, we could take this to trial, but you're going to lose because I don't have the money to call forth witnesses, or we don't have a lot of time. If you're the typical defendant, you have a public defender, and they have an average of 2,000 cases a year to deal with. It's about 5 cases a day every day. You're not going to get a trial, but if you do, you're probably going to lose. Then you'll probably take the plea bargain, even if you're innocent, because it's a better deal than facing the maximum if you lose a trial. So this is a serious problem. It's interesting that both conservatives and liberals seem to be against plea bargaining. Liberals oppose it because it's a violation of your due process rights. You don't get your right to trial. Conservatives don't like it because guilty people get far less than they deserve through a plea bargain. So basically, we're not really giving people what they earn in terms of punishment, and we're giving some people too much. But the only problem is, or I should say the only solution to plea bargaining, is to have less cases and or more funding for the courts, and specifically more funding for defense attorneys. Remember that in criminal justice, about 45% of the money we spend goes to police, about 33% goes to corrections, and 22% goes to the courts. That's based on the stuff we learned earlier in the semester when we looked at the crime control versus due process model. So about 22% of money that we spend goes to courts. Most of that goes to the prosecution. It doesn't go to the defense. So if we want to have more trials, we have to spend more money on defense. We also need less cases. And the only way to have less cases is to have less arrests, which means either you stop arresting people for things that are illegal, or you make things that are illegal not illegal. So you might ask yourself, what would be some things that are illegal that you don't think should be? That's up to you. The voters decide this, right? Our lawmakers decide this, but we vote for them, right? So if you want to legalize something like marijuana, you have to make your legislature do that. And the states that have legalized things like marijuana have less arrests for marijuana, obviously, less people in the courts for that, and therefore they can devote more money and resources to trials for serious crimes like murder, rape, robbery, etc. Okay, it's something to think about going forward. What we can say about plea bargaining is it's definitely inconsistent with the ideals of criminal justice. You're supposed to have a trial. It's supposed to be a battle for the truth. And plea bargaining is simply a mutual agreement out of court to dispose of a case as quickly as possible. So if you like due process, if you're a due process proponent, then you'll seriously have a problem with plea bargaining. Getting away with it, or getting rid of it, is a major challenge, obviously. Now, there's some other things in the chapter about private versus public attorneys. What you'll see is that there's really not much of a difference between the two. This is discussed in your book and your notes. Basically, ideally, you have a private attorney if you can afford one, and there are some advantages to that. Private attorneys get their clients released from during the pretrial phase more often than public defenders. Private attorneys get their clients sentenced to prison less than public defenders. But if you have a public defender and you're sentenced to prison, on average, you're going to get a shorter sentence. And that's probably because the public defender is a member of the courtroom work group. So they know the prosecutor and the defense attorney, or excuse me, they know the prosecutor and the judge. But the conviction rates are about the same in terms of private versus public attorneys. You should look at something called the wedding cake model. So Google that. The wedding cake model in criminal justice is a discovery that there are different trial setups for people based on the types of crimes they're accused of and the amount of money they have. So the highest level in the court is these really celebrated or celebrity cases. The second level is the really high level felonies. And the third level is everything else. Basically, the level of the cake, if you will, the wedding cake model, the higher the level determines the likelihood that you'll get a trial. So you do see examples of very powerful and wealthy people getting trials with competent, wealthy, successful defense attorneys. Most of us get arrested and we don't even get a trial because we waive our right to trial through plea bargaining. So when I talk about the typical courts, for the average person, that's what I'm talking about. Not like the O.J. Simpson dream team type situation where he had the best attorneys money could buy, right? What did he find, by the way, with the money he spent? He found reasonable doubt. It was that they were able to find reasonable doubts, even though he was guilty without any question. They were able to find reasonable doubts to convince a jury that they shouldn't convict. There's also a discussion of the different phases of a trial. And the one thing I want to focus on as you go through the trial phases in terms of the stages, but really the one that stands out the most to me as a criminologist and as a person who's been on a jury is the voir dire process. Voir dire is French for to speak the truth. And this is what we call, voir dire is what we call jury selection. And this is where the prosecutor and defense attorney, with the help of a judge, try to pick a jury, or actually pick a jury by asking them questions. And ideally, they don't try to stack a jury in their favor, but what they do use is what are called peremptory challenges to stack the jury. So a challenge for cause is unlimited. You can eliminate someone from a jury for a valid reason, and those are unlimited for logical reasons. So if you have, let's say you have a trial, the black person accused of a crime against a white woman, for example, like a black man allegedly raped and murdered a white woman. If you have racists in a jury, they're going to be eliminated. Prosecutors and defense attorneys in particular are going to try to eliminate those people. If you know someone who's involved in the case, you're going to be eliminated for cause. These are valid reasons to eliminate someone. If they determine that you just don't like the police and you'll never convict someone, you'll be eliminated for a valid reason. Peremptory challenges go back to English common law. These are limited in number, but you're allowed to eliminate people for no reason whatsoever. You have a bad feeling about someone or what have you. This is what we know, and so there's some additional readings embedded in your PowerPoint slideshow that examine the use of peremptory challenges, and some of them are from the state of North Carolina. So in capital cases in North Carolina, death penalty cases where someone's life is on the line, we have evidence that prosecutors use peremptory challenges to eliminate black people. This is against the law. You're not allowed to do this. And a defense attorney finds out that a prosecutor is eliminating someone based on their race, or if they think that the prosecutor is doing this, they can challenge that. And the prosecutor has to come up with a race-neutral explanation for it. It doesn't have to be a good reason, according to the courts. It just has to be an alternative reason, believable reason. So what's happening is prosecutors in many states are eliminating people of color using peremptory challenges. This is a threat to fair trials for people, and it often leads to death sentences, like we can confirm in North Carolina. People who were actually removed from death row in North Carolina based on the use of peremptory challenges by prosecutors. Now, those death sentences were later reinstated, which seems like double jeopardy, but they were reinstated after our Racial Justice Act was struck down by the Republican legislature after the Democratic legislature had passed it. So you can examine that too through Google if you're interested in that particular case. We'll get back to that when we talk about the death penalty later. Okay, there's some stuff about jury instructions and jury deliberations. It's pretty straightforward. Jury instructions are not typically understood by people. Jury deliberations mandate only certain things are allowed to be considered, but we know from mock jury studies and interviews with jurors after the case is concluded, like the Capital Jury Project, which is a study of capital jurors, like people who've been on death penalty cases. We know that jurors consider things that they're not allowed to consider. That's a problem, obviously, as well, especially if they're considering things like what the defendant looks like, what they're wearing, and things like that. I'd love to tell you guys the story of what I saw on my jury when I was jury foreperson of a kidnapping robbery case in Watauga County. We did have one juror make a comment about what the defendant looked like, and everyone in the jury called him out and said, "You can't do that." And we made sure that was not considered in our deliberations. But the point is, I'm a criminologist. I know this is not supposed to happen. So I called him out. I don't know how many other jury forepersons would be so quick to notice that. So what's the meaning of all this? Even with trials are very rare, which is upsetting if you value due process. But even with trials, we don't necessarily know they arrive at the truth. We have wrongful acquittals. We have wrongful convictions. There's some readings about that as well, particularly wrongful convictions. And I can't think of a worse threat to justice than an innocent person incarcerated for something they didn't do. All right, I'll stop here, and the next video will be about, it'll be short, but it'll be about post-trial and sentencing and some of the issues there.